This was a termination case, correct?
Correct, Your Honor.
And ma'am, what's your claim to your ability to reside in the premises? Miss Atkins?
These are the new documents that they filed, but they're back and forth.
Got it.
Your Honor, if those were emailed to the court, obviously the court's aware, but just for the sake of the record, nothing was emailed to me.
Yeah, I got it, counsel.
Thank you.
Yeah, you can forward them to them. I mean, we're going to try to forward those to you, counsel, so you.
Thank you, Your Honor.
I have a property transfer affidavit from January 25th of 2023. The seller being Gene, is it Facio?
Falciccio, Your Honor.
Falciccio. And that the buyer is Casey Atkins.
Your Honor, Miss Atkins filed 2 property transfer affidavits on the date of her mother's death. The property is not, Miss Falciccio died in January. She passed. Both of the properties that were, one, an eviction's already occurred. This is the last one, are titled in the name of the trust. So that affidavit is a fraudulent transfer affidavit. Title remains, and I could show the court the deed and the recording information, but title remains vested in the trust.
Got it. Okay, Isabel Atkins, what is your claim to the premises that's at issue here?
I would like to request a jury trial. I lived with my grandma for a year.
Ma'am, you've got to file paperwork and you've got to pay for the jury. Are you going to do that today? And then you're going to have to file an answer to the claim.
Yes.
So the court is aware, just from a timing standpoint, I did just receive the email from the court showing photos, which appear to be the photos of the property being removed from the first eviction unrelated to this property. There was a proper notice sent for possession. A notice to quit was sent all the way back on May 18th, giving them until June 30th to vacate. We delayed the filing of the eviction to give her even further time. There's no defense that's been raised, and even her claims on the record here that she would simply like to stay do not give her grounds. There's no lease. She needs to vacate the property, and at this point, we'd ask for no further. This is the third time they tried to delay this. We'd ask for no further delay and for the judgment to be entered. Not seeking any money judgment here, obviously, Your Honor, but just asking that the court enter the judgment and an order of eviction in 10 days.
Miss Isabel Atkins?
Yes.
What is your basis for claiming that you can reside in the premises?
My grandma said that I could.
Okay, ma'am, that's not going to be enough. I don't really have an issue that I could try or a jury could try on this case.
For the sake of the record, Your Honor, I would like to ask, is Miss Atkins alone, or is Miss Casey Atkins with her? Because Miss Casey Atkins, who's not a party to this case or an attorney, continues to appear on the Zoom.
No, I'm on the Zoom. I'm not with Bella.
Okay, Isabella?
Sir, the request is that we would like to get it moved to probate, as the trustee is not listed as the plaintiff.
Ma'am, you are not a party to this case.
Your Honor, now that she's muted, just so the court is aware, Miss Casey Atkins tried to file a probate action in front of Judge O'Brien, which was just recently dismissed. This is just a sort of belaboring continuous fraud to keep the properties in play, and we would just ask for the judgment at this point. I really don't want to belabor the issue further.
Andrew,
All
that's
right.
not true. Y'all haven't filed the will.
Yeah, Miss Atkins, Casey Atkins. I've now for the third time told you you are not a party to this case. Isabella Atkins, tell me every reason outside, well, you said your grandmother said you could reside there. Any other reason you think that you're able to reside in these premises, ma'am? Isabella Atkins, are you there?
I will file paperwork.
You what?
I will file paperwork, but I would like the right to have a jury trial.
Well, ma'am, I need to know that there's a defense to the claim.
Your Honor, this may be strangely odd, but I'm concerned that may even be Isabella Atkins on the phone. If the court recalls, when this started, there was a different number that was saying it was having issues calling in. Now there's a new number, video, but the age of the voice, I'm just concerned. Candidly,
I hear you. I got you. Miss Atkins, Isabella Atkins?
she just left.
logged off. Okay, here's what I'm going to do.
Sir, she's calling me right now. Bella, are you on the phone? You're on the phone with the speaker with the Zoom, Bella. It's okay. Sir? Hello?
Isabella Atkins.
Bella, answer.
I don't know. Well, I don't know how to answer this question.
Okay, I have a very clear picture now of what's going on here. So here's what I'm going to do. Because I don't think this is, I think Isabella's there, but Isabella, I don't think wants to pursue this in this fashion. So she's going to have to get an attorney so that the record's clear. I think much of this is being instituted by Casey Atkins, who's not a party to this case. So I'm going to find that there's no tribal issue in this case after hearing. I'm going to grant a judgment for possession to the plaintiff with a writ 10 days.
Thank you, Your Honor. Your Honor, can the proposed orders be submitted to the court via email, or do they need to still be paper?
Yes, that you can submit them to the clerk's office via email.
Thank you, Your Honor.
Thank you.
The courtroom reached its breaking point as a disputed eviction case unraveled before the judge. Isabella Atkins claimed she had the right to remain in the home because her grandmother had given her permission, but she failed to provide any legal evidence supporting that claim. Meanwhile, Casey Atkins, who wasn't even a party to the case, repeatedly interrupted the hearing, prompting the judge to remind her multiple times that she had no legal standing. The landlord's attorney argued that proper notices had been served, previous delays had already been granted, and the property legally belonged to a trust, not the defendants. As confusion grew over who was actually speaking during the hearing, the judge concluded that there was no valid legal defense and that the case was being unnecessarily prolonged. In the end, the court ruled in favor of the property owner, granting possession and issuing a writ of eviction within 10 days. The hearing served as a powerful reminder that emotional claims and family promises cannot override property law. Only legally recognized rights and evidence determine the outcome in court.